Hi everyone, I am Vidushi. Welcome to Legal Rabbit. We are starting off with the ISC syllabus for legal studies, class 12. So, this is the unit on ADR, Alternative Dispute Resolution. I'll be uploading videos on my YouTube channel in this playlist. This is the first session, and today we'll be covering judicial and quasi judicial bodies. There is a Telegram channel that we have. If you wish, you can join that channel. In addition to that, we have online and offline batches going on. You can get in touch with us. There is a contact number in the description box. So let's get started then. So as I have mentioned, I'm starting off with the chapter on ADR, and we'll move as per your syllabus. So the first topic that is mentioned under your syllabus. So let's start with judicial and quasi judicial bodies. So, a lot of you might be aware of the fact that the government has three major branches. What are these three branches? The executive, the legislature, and the judiciary. The judiciary is responsible for handling the legal matters in our country. How does the judiciary perform all these functions? So, under the judiciary, we have a set of judicial bodies. These bodies conduct all the judicial functions, all the legal functions, all the legal roles in our country. Alright, what is the structure of these judicial bodies? So, the basic framework of the Indian judiciary, which says that the Supreme Court of India is the highest court and is at the apex. Then you have the high courts, which exist at the state level, and then you have the lower courts. So basically this is the structure of the Indian judiciary, and this is the what? Hierarchy of the judicial setup in our country. So let's go through these points once. The judicial bodies are an integral part of the judiciary, which is one of the three branches of the government alongside the executive and the legislature. Right? So executive, legislature and judiciary, which are the three branches of the government. Judicial bodies in India constitute the core of the Indian judicial system. So when we talk about the judiciary, under the judiciary we have the judicial bodies. These judicial bodies take care of all the legal work, all the judicial functions, everything with respect to law and resolution of disputes is done by these judicial bodies. So they are at the core of the judicial system, core of the judiciary. The Indian judicial system is a hierarchical structure with the Supreme Court at the apex, followed by the high courts at the state level and the subordinate courts at the district level. So we just discussed this, how the judicial bodies are in an hierarchical way organized as the Supreme Court at the apex, the high court at the state and the union territory level, and the lower courts which exist at the district and lower levels. Now see, we know that we have judicial bodies in our country, and these bodies form the core of the Indian judiciary. This much we know. But with time, certain problems started coming up. What kind of problems? For instance, the workload of the judiciary really increased. Secondly, the workload is increasing on one hand, but the strength of the judiciary in terms of the number of people we have to look into these cases, in terms of the judges we have, all of this is still not adequate. So what happens? There is a pendency of cases. Cases stay unheard and unresolved for very, very long. Thirdly, another issue that arises is, see, these judicial bodies which we have, Supreme Court, High Court and lower courts being the main structure, in these judicial bodies, the people who are administering the justice, the judges, they come from a legal background. But a lot of them do not have specific expertise on certain issues. For example, if there is an issue with respect to the environment, all right, now here maybe a judge can look into the matter legally, but he or she may not have the relevant expertise to look into an environment related matter. So an expert in the field of environmental affairs would understand more about the case which specifically deals with the environment. So there was a need for experts. In certain areas, it became important to involve experts in the process of imparting justice. Right? So here the judicial bodies didn't have those experts. This was also a problem. Fourthly, all these judicial bodies that we are talking about, they follow certain standard rules and procedures. For example, if you go to the High Court of India or if you go to the Supreme Court of India, then you have to go by all the rules and procedures that are mentioned in order to proceed with your case. So the entire process that is involved with these judicial bodies are all very formal, and you can say to some extent slightly complicated, which is also one reason why the cases would stay pending for very long, because you would have to satisfy all the legal technical requirements in order to proceed with the case. Considering that these problems started arising, we needed a different set of body. We needed some such body which will be able to perform the judicial functions, but at the same time that body is not a complete court, that body is not a complete judicial body. That body would be such a body which would be able to resolve disputes, which would also be able to come up with penalty, which would do a lot of things which a judicial body would do, but at the same time it will not be a complete court. Then came the existence of something known as quasi judicial bodies. So basically, a quasi judicial body is what? When we say quasi, then we mean it is somewhat like a judicial body. So we will study about quasi judicial bodies in a little more detail in a couple of minutes. But have you understood why these quasi judicial bodies actually came up? So these are couple of reasons why we can say that there was a need to have another set of bodies other than the judicial bodies in order to ensure that justice is imparted more efficiently. All right, first just get an idea of the points once more. Quasi judicial bodies are not part of the standard judicial system in India. Thus, they are not traditional courts. So, when we talk about the Supreme Court, High Courts, and lower courts, then this is the standard judicial system. These are the traditional courts. If you were to talk about quasi judicial bodies, then they are not part of this standard judicial system. They are not traditional courts. They are bodies that have powers and procedures resembling those of the law courts. They can adjudicate a case and decide the penalty for the guilty. What does a traditional court do? A traditional court adjudicates a dispute, okay, and it decides whatever is going to be the penalty. All right, and one more very important thing, it operates under the principle of natural justice. Just to give you an idea, what are the principles of natural justice? One is that in a case where there are two parties, A and B, involved, both these parties should be given an opportunity to present their arguments. Okay, it should never be like that the court has come to a decision without listening to one party. So you must listen to both the parties. Both the parties must get a fair chance to present their cases. And secondly, the person who is resolving the dispute, so the judge, that person should be an impartial person. There should be no bias involved. So judicial bodies broadly perform these functions. They adjudicate a dispute, they decide the penalty, and they make sure that they're following natural justice principles. If you were to look at quasi judicial bodies, these quasi judicial bodies also perform these functions. So, this is how these quasi judicial bodies, though they are not traditional courts, though they are not part of the standard judicial system, but they resemble courts. All right. So the powers that a quasi judicial body will have will be to adjudicate a dispute, will be to decide the penalty, and of course, it has to go by the principles of natural justice. So, therefore, there is a resemblance between quasi judicial bodies and standard judicial bodies, traditional courts. Okay. They operate under the principles of natural justice, ensuring fairness and transparency in their proceedings. Their procedures can be less formal than those of traditional courts. So we just discussed that, see, in these traditional courts, the process that is followed, from the beginning to the end. Everything that is involved in processing a case is a very formal process, and it's a stringent process, which means it is a more difficult, complicated, and less flexible process. If you were to look at quasi judicial bodies, see, they are not part of the standard judicial system. They are not traditional courts. They resemble courts, right? So here, their process and procedures can be less formal in comparison to the traditional courts. Quasi judicial bodies play a crucial role in the administrative legal framework, bridging the gap between the judiciary and the executive branches of the government. Now, let's quickly go through the points where I have just put down the reasons for the emergence of quasi judicial bodies. Why did quasi judicial bodies emerge? We already had a standard setup, right? We had Supreme Court, High Courts, and lower courts. We had that hierarchy. So then what was the need to have these quasi judicial bodies? I had just discussed this with you a couple of minutes back. Let's go through these points once again. Judicial bodies help to reduce the workload on the traditional judicial setup. Traditional judiciary has a lot of workload, lot of pending cases, and therefore to reduce their burden, we needed another set of bodies, which would be quasi judicial bodies. Time saving. Pendency of cases in courts is one of the key challenges faced by the judicial systems. Quasi judicial bodies will help to reduce the pendency of these cases, because now a couple of cases will get transferred to quasi judicial bodies. So obviously the workload on the judiciary will reduce, and a lot of time will get saved. Quasi judicial bodies provide faster adjudication as compared to traditional courts. Another point that we just discussed was the need for experts. In certain technical cases, the traditional courts need expert knowledge for adjudication. Quasi judicial bodies having experts who are empaneled to provide expertise on cases involving certain specific subject matter. So, the need for experts. There are certain cases which come up on very specific matters, and then we need experts to be able to handle those matters. So, quasi judicial bodies, in their panel, they have such people who may not be from the legal field, who may not be judges, but then they have expertise with respect to that particular issue. So, this requirement of having experts to deal with cases on specific subject matter was also satisfied by quasi judicial bodies. So, which is one more reason why we needed quasi judicial bodies. And flexibility in procedures. We have just discussed this. Quasi judicial bodies follow principles of natural justice but do not have to strictly comply with the legal procedures in a traditional court. See, principles of natural justice, these are certain universal legal principles, okay? Everywhere they are followed. Even quasi judicial bodies follow principles of natural justice. So, as far as the principles of natural justice are concerned, quasi judicial bodies follow that, but they don't have the mandate of strictly following all the formalities that a traditional court would follow. And that is the reason that quasi judicial bodies are a more flexible forum, more flexible place in terms of procedure. All right. So now there are a lot of quasi judicial bodies in our country. I'm just giving you two examples. I would encourage you to look for more. The National Consumer Disputes Redressal Commission. Now, this commission, by the name you can understand, looks into matters specific to consumer disputes. In today's times, the consumer has a lot of rights. Okay, consumer matters are taken very seriously. If you go, you buy something and you're not satisfied with the service, or you go to a shop and something is stale, you can go to the Consumer Redressal Commission. So, consumer disputes is a serious matter now. We have something known as Consumer Protection Act of 1986. This is the main law. Now we have a newer version of this law, and under this law, under this act, the National Consumer Disputes Redressal Commission was established. What is it? It is a quasi judicial body. So it's not a traditional court, but it is similar to a traditional court. Similarly, for environmental matters, okay, for environment related matters, you have what? You have the National Green Tribunal, NGT. So NGT is also a quasi judicial bodies, and there is something known as the National Green Tribunal Act 2010. So this is the law, and under this law, this NGT, this tribunal, this body was established. It's also a quasi judicial body, not a traditional court, but similar to a traditional court, with people from the legal fraternity and with experts from the environmental fields to come and resolve disputes related to environmental protection. Okay, you can obviously look into and find out some more examples of quasi judicial bodies that we have in India. Now that you have an idea of what a judicial body is and what a quasi judicial body is, let's look into the differences between these two. This column talks about your point of distinction, and under these two columns, we will be discussing the differences. So, first of all, what is the meaning? Judicial bodies are an integral part of the judiciary, which is one of the three branches of the government alongside the executive and the legislature. Their primary function is to adjudicate disputes, interpret laws, and deliver justice. So, this is what is the traditional judiciary. We have already discussed this. Three branches of the government: executive, legislature, and judiciary. The judiciary has a set of judicial bodies which look into the adjudication of disputes, which look into interpretation of laws, which look into delivering justice. What is a quasi judicial body? Quasi judicial bodies serve as specialized adjudicatory forums. Adjudicatory forum, a place where a dispute is resolved. And why specialized? Because remember, I just told you that these bodies are for specific cases related to certain specific subject matter. Like we just discussed, the Consumer Redressal Commission deals with consumer matters. The National Green Tribunal, NGT, deals with environmental matters. Okay, these are not traditional courts, but they resemble courts. Obviously, they are not part of the traditional judicial setup. They are not traditional courts like the Supreme Court, High Courts, District Courts, Lower Courts. No, but they resemble courts. Now, what is the nature of the authority? Judicial bodies are run by judges, and judges have the authority to do what? When a case comes to them, they look into the facts, they look into the law, they interpret the law, and they apply it in the case. All right. So, judicial bodies have the authority to interpret and apply laws across a wide range of matters as per the constitution and legal statutes. Now, when a case comes to the judiciary, say a case comes to the district court, or it comes to the high court, or it comes to the Supreme Court, that particular case does not have to deal with a specific matter. Like if you go to a quasi judicial body, say if you went to the NGT, the National Green Tribunal, then you can go to the NGT only if your case has something to do with majorly the environmental issue. So it's an environmental related dispute. But if you talk about judicial bodies, which are the traditional courts, then a case which is going to any traditional court, be it the Supreme Court, be it the High Court, or be it the lower courts, it can go on a wide range of matters. It can be murder, it can be kidnapping, it can be contract law, it can be some property law, it can be family issues, it can be so much. Okay, and the court will then refer to the constitution and other laws that we have to come to a decision. But if you look at quasi judicial bodies, while also interpreting laws, typically do this within a specialized or limited area of expertise. Cases which go to them deal with those specialized areas. So it is limited. So basically, what can we say? That the scope of functions for judicial bodies is much more wider, it is more broad, right? Because any kind of legal matter can go to a traditional court, right? But quasi judicial bodies can conduct hearings, make legal judgments, and resolve disputes, usually within the confines of the area which they govern. So, quasi judicial body, in this sense, the scope of functions is limited because it deals with that specific area. Whereas, in case of judicial bodies, the scope of functions is broad. Okay. Remember, we had discussed about procedures. Traditional judicial bodies have what? lengthy and complex procedures. Judicial proceedings follow strict legal procedures and are formal in nature. Whereas if you were to look at quasi judicial bodies, remember we discussed that just like courts, they adjudicate disputes, they even decide the penalty, and they even follow natural justice principles. At the same time, their procedures are not lengthy and complex. So they do not have lengthy and complex procedures. They are more flexible in their procedures. But as far as following natural justice principles are concerned, everyone, any body which is doing any kind of adjudication, legal adjudication, has to follow natural justice principles. A judicial body also follows natural justice principles, and a quasi judicial body also follows principles of natural justice. Couple of minutes back, when we were discussing why quasi judicial bodies actually came into existence, then if you remember, we had discussed one point on the need for experts, right? That there are certain issues where we needed expert members who have more in depth knowledge in that field. So if you look at the composition of these two bodies, you will see that as far as judicial bodies are concerned, they have qualified judicial members, like they have judges. Judges are people who are duly legally qualified to handle legal matters. They have pursued legal education, and they have attained the necessary degrees to become a qualified judicial member. So the composition of the judicial body consists of judges. Whereas if you look at quasi judicial bodies, there they have both judicial members and expert members. Judicial members are required because they have the technical legal knowledge, they know how to handle the case legally. And there are expert members. Expert members are required, why? Because they have specific knowledge in that field. Here you have only judges, judicially qualified people, and here you have both judicial members and expert members. I had just mentioned to you some time back that our judicial setup is a hierarchy of courts. Supreme Court at the top, High Court at the state level, and lower courts at the district level. Now, if you are not satisfied with the judgment that a lower court is given, then you can go to the High Court. If you are not satisfied with the judgment the High Court has given, then you can go to the Supreme Court. So, generally, this process of appeal, the process that you are appealing from the lower court to the higher court and higher court to the Supreme Court, you are wanting your decision to be reviewed. This happens in this hierarchical way, which means you have to follow this path. You generally cannot cross this barrier and go to the Supreme Court. There are specific issues in which you can go to the Supreme Court directly, but generally you have to follow this hierarchy. If you want to appeal, you're not satisfied with the lower court's decision, you want to appeal to the higher court. You cannot appeal to the Supreme Court from here directly. Okay. Now, if you were to talk about quasi judicial bodies, see, in quasi judicial bodies, you can bypass the traditional appellate court system. Appellate comes from the word appeal. Basically, when you appeal from one court to the other court, it is an appellate process. But if you were to talk about quasi judicial bodies, there you can bypass this traditional appellate court system. For example, if a case goes to the NGT, the National Green Tribunal, which is a quasi judicial body, and you're not satisfied with the decision that the NGT has given, you can directly appeal to the Supreme Court. So see, it is not that you went to a quasi judicial body, you were not satisfied, and then you had to again all over again start from the lower courts, then go to the high courts, and then go to the Supreme Court. All right. So you can bypass the traditional appellate court system. If you talk about the jurisdiction, we have just discussed this point some time back. Jurisdiction is the area in which they can operate. For example, jurisdiction can be a local area. This is the district in which this court operates. This court has power to resolve disputes. That is jurisdiction. It can also be a subject matter. Like certain courts deal with civil matters, so their jurisdiction is to deal with civil matters. Certain courts deal with criminal matters, their jurisdiction is to deal with criminal matters. All right, so This is the meaning of the word jurisdiction. Now, traditional courts, which means judicial bodies, have a broad jurisdiction. Remember, I just mentioned to you that if you go to these traditional courts, then you can approach these courts on a variety of issues: criminal issues, civil issues, family issues, property issues, contractual issues, so many different types of issues. So they have a broader jurisdiction because they are not specializing in one particular domain, right? But if you talk about the quasi judicial bodies, then they have a narrow jurisdiction. Why? Because they are limited to their specific area of expertise. If it's the consumer commission, it's only consumer disputes. If it's the NGT, it is only environmental matters. So, which is why the jurisdiction is narrow. I hope this entire aspect of quasi judicial bodies and judicial bodies is clear to you. We have a Telegram channel by the name of Legal Rabbit. You can come and join that channel. You will get access to all these notes. In addition to that, we also have online and offline batches going on. So if you would like to join any of those batches, then do feel free to write in the comment section, and the description has a contact number. You can get in touch with us to join any of the batches. I hope this is clear. If you have any doubts, I'll be really happy to help you. You can write to me in the comment section. See you in another session. Bye bye.